Welcome to Lawyer Up with HMC, where we unravel the complexities of legal battles, share insights into high-stakes litigation, and provide strategies for navigating the legal landscape. Join us as we delve into and discuss common legal issues and interview industry professionals and experts in the field. Whether you're a legal professional, a business owner, or simply curious about the world of litigation, our podcast offers valuable knowledge and practical advice to empower you in your legal journey. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Now here's the host of the Lawyer Up with HMC podcast, Kristen Hagg.
Well, welcome to another episode of Lawyer Up with HMC. Feels pretty good to say that after getting the first episode under our belts. I'm your host, Kristen Hagg. With me once again is my associate, Praveen, who has the honor of introducing this week's guest, Allan Shewchuk.
Thanks, Kristen. Good morning. Excited to have our second episode and especially excited to have Allan Shewchuk with us here today. He's been a civil litigator for over 35 years, has specialized in personal injury law. He now limits his practice to acting for Alberta Justice, dealing with injured and disabled Albertans. And he is acting as a mediator now with a view to a fair and reasonable result for litigants. So thanks for being here today, Allan.
Great to be here with both of you. Thank you.
And Allan, how many years have you been mediating now?
Well, on and off, probably for about 10, but really only about the last 3 was where things have really taken off for me. I think some of that, without even advertising, it was the advent of Zoom, actually, where people could mediate. If clients were in different cities or different provinces, it just became an easier process. And so I think things have really taken off for me. So it's mostly what I do right now.
Yeah, well, we're very happy that you're mediating a lot. Obviously, we have a relationship going back with you quite a few years. I think your relationship with HMC predates us being known as HMC. It predates when I started working here 12 years ago. Tell us a bit about your history with our firm.
Sure. Well, actually, it probably predates your birthdays, guys. So I started dealing with your predecessor firm over 40 years ago when I started practicing law. And, and I will just say that right from the outset, you guys have been certainly one of the premier litigation firms in all of Alberta, maybe Canada. So I've had an awful lot of dealings with you guys. And lately an awful lot with respect to mediations, and which is interesting because when you start out having claims with people or cases with people where the ultimate end was always a trial if you didn't resolve it, that's completely flipped around now, and that's going to be one of the topics we're going to talk about today, which is how trial has now become the non-preferred way of resolving things, and by a mile. But that's been, I've been going to court for people since 1981, so I've been doing this a long time. But I really believe now, after mediating so much in that process, and I've seen miraculous results for some people.
Yeah, I mean, like you said, we're going to get into it a little bit more later, but it's such a huge part of what we do now as litigators, and I'd agree. It's a really important topic for us to get into. But before we get to that, I was going to say we feel very lucky to have had the chance to get to know you professionally and personally. But something else we learned while preparing for today is that you are actually a more seasoned online media personality than we are. You've been a co-host, co-creator of 2 different cooking shows, Cook Like a Surgeon and Close to the Bone. So I have 2 questions for you.
Yes.
Do you already feel pretty comfortable in front of the camera or the mic? I guess doing mediations might have helped with that too. And when and how did you become a chef?
Well, I do feel very comfortable in front of a camera. For about 10 years, I was the media spokesperson for the Law Society of Alberta. I was asked regularly when I was younger to appear on CBC News World if they had a legal issue. So I've been doing this a long time. my foray into the food business really started when I was a boy, because I grew up literally stuck between two Italian families on either side of me, and I was always fascinated with the whole process of, and this is when I was, back in the early '60s, where very typically the family would not live in the upstairs of the house. All the furniture would still be covered in plastic, and they basically they basically lived in the kitchen and made their own wine. So my boyhood Italian friends always smelled like fresh bread and wine, and I was really fascinated by the whole process. And then I started to travel to Italy, and I lived in Italy a couple of times. And this is before the advent of food television. And I came back with all kinds of recipes from rural Italy or regions of Italy that people never heard of before. And because of that, my brother, who's actually a very famous barbecue chef, several award-winning cookbooks, and he won the Canadian Barbecue Championship and competed at the Jack Daniel's Barbecue Champion. Through him, I got asked to teach Italian, some of the stuff I knew at an Italian cooking school, and I've been doing that for 28 years now. The television part of it came out of that, and the worst television show ever was Close to the Bone. I'm not kidding. A surgeon has been watching a television show, a cooking show where the camera was going around the kitchen and the chef was barking out orders, and he thought, "Wow, this is just like an operating room." He decided that he would want surgeons to be on as guest cooks, and so what happened every week is a surgeon would come on and talk about the part of the human body that he or she operated on, and then we'd go to the butcher shop together and we'd buy the corresponding animal part and cook it together. It had an enormous squirm factor to it.
It sounds like a great idea, but yeah, it's sometimes hard to execute these things, as we know. So,
and my TV career ended when I was doing a show about cooking with spirits, with liquor, and then the last show they lit me on fire by mistake. So that was the end of my career at that point.
I could see why you would want to move on to other things after that.
But the other thing I will say to people listening is that one of the things I've enjoyed about having one toe in the cooking business is that it's allowed me to meet all sorts of different people in the food business and and entertainment business and hospitality business, and it's just really interesting to learn how those people make a living, how they make money, what their day-to-day lives are like, because it's so different than what I do all day, and it's been a really wonderful break for me to just have that sort of aside, because all work and no play makes Allan a boring boy. So there you go.
It's nice to get away from our lawyer bubble at times too, and meet people from different walks of life, different backgrounds, and I think it helps us better at our profession too. But I do want to delve into mediation and generally what that means. Some of our viewers have no familiarity with this concept. Some may know a little bit. But could you explain what mediation is and how it differs from other forms of dispute resolution?
Sure. And I guess the first thing is that one of the things it does, if people are in our legal system or court system and are on a collision course to go to a trial, it's a voluntary process where people agree to come together in an environment with someone like me as a mediator, not to tell people what to do, not to make decisions, but to facilitate a negotiation or a discussion, and work towards a resolution together. It isn't always very collaborative in that sense, because people still want to advocate for their clients and put their best foot or better than their best foot forward a lot of the time. But it's a very, I'll just say this right at the outset, it's a very strange process, because very often people start off so far apart in their positions. As I always say, they're not two ships passing in the night; they're on different oceans. And oddly, the process works, and usually by the end of the day, you're either really close or you're done. And it is really fulfilling for me to be the person that gets to facilitate that process and to get people to resolve. It's different also than arbitration, which is another way you can go not going to court. But there, what you're doing is you're putting an arbitrator in the position to decide for you, the same way a judge would. But the thing is, it takes you outside of the court system. So the advantage of an arbitration, like a mediation, is you can pick that person to sit with you who actually knows the area of the law or the area of your dispute really well. In other words, you're basically picking an expert to try and help you. I'm hopeful for me, after over 40 years of practicing personal injury work, that I can really provide some insights to people when I mediate for them.
Right. And I guess it allows litigants to, and lawyers as well, to maintain some level of control over the process. And I guess we'll get more into that later. But now, to ensure we had all the goods from the mediator's perspective, you had provided us with a LISA seminar presentation to come up with a little bit of material. And in there it says that the role of a mediator is a cross between Gandalf and a boxing referee without the magic wand or the bow tie. Does that sound about right to you?
Yeah, it does. And again, that depends on first of all, the Gandalf part really depends on what like I just said a minute ago. Somehow there is some magic in this process about how really disparate positions can all of a sudden sort of come together and get really close, and you can watch it almost in slow motion. It's there's a momentum to get things resolved, and all of a sudden people start moving their positions and actually being a bit more collaborative and agreeing on certain things. And I don't. That's the Gandalf part. I'm not sure how that happens. But some of it is because when in a mediation, when people break out into caucus rooms and the mediator comes and talks to them privately, it is private in there, and you can be really frank. They can be frank with me, and I can be really frank with them about what I think. I don't usually try to intervene too early, but it really is a strange kind of a alchemy that happens when people mediate, and I think especially if it's really acrimonious. I know that in my area of the law, it's not often that acrimonious, but for example, in family law, oftentimes parties who couldn't stand to be in the same room or even talk to each other, all of a sudden it allows for people to maybe to see that the other side, there's some give and take, and it's starting to be more of a fair process. As for the boxing referee, sometimes the mediator's job is to get people to back off very aggressive positions, and to stop people being foolish about their positions, really, and about how they move in terms of the negotiation. And I often have to say to people, look, you've got to make some kind of a move here to give the other side any sort of a hope that we're going to get this done. And very often that is what happens at a certain point, is people actually have a shift. And that's the boxing referee part, is sometimes you have to force yourself to bring people, push them apart, and get them to sort of take a deep breath and then get back into the negotiation.
I have to admit, when I first saw the analogy, I was like, I have no idea what this means, but you just explained it unbelievably well. So thank you.
Very well.
Yeah.
Do you find it sort of a balancing act between being Gandalf and the boxing referee, or you putting one hat on rather than the other in a certain setting?
Well, I think you have to take the first thing you have to do is very early on take the temperature of the room in terms of what people are doing, and I think the other thing, and this is the hard thing about virtual mediations, is it's really hard on virtual mediations to try to connect with people, particularly if in an injury case, for example, an injured party, the plaintiff, who has probably been in the litigation process for anywhere between 4 to 7 or 8 or more years. They probably come with a lot of trepidation. Sometimes they come with a lot of anger or frustration, and I think the key is to connect with them. And if you can do that and win their trust, then I think the lawyers are very happy to have you talk to the client about where things might lie, rather than them having to do it. I mean, my personal side, I'm never an arm twister or a bully, but sometimes you really have to lay out the facts about what the realities of going to a trial might be. And I think that's the most important thing about telling people at a mediation is this is your chance here to be a part of the process. Otherwise, you're turning it over to somebody else, and you don't know what's going to happen.
And leaving aside, I guess, with the virtual stuff, the ability of you to connect with somebody might be hindered a bit. But do you think for particularly individual litigants, not professionals or whatever, it might be more comfortable for them to be, from their own home on video? Or have you noticed any difference with that?
I actually think that the advantage of virtual mediations or virtual proceedings is it does take a lot of the stress out of it, particularly for laymen. If someone now I have seen people show up for mediations in their bathrobe, which sort of does take a little bit of the formality out of it. And I know that there's old school, barristers or people that were trained to go to court like me, who they like the sort of trappings of a court environment or a more formal environment, because they think it makes people behave better, frankly, and have a bit more respect. But I do think being comfortable in the process is the most important thing, and that's what I like best about mediation is. Um, Otherwise, these people are having to walk up into a witness stand and in front of a bunch of people, talk maybe about very personal things, and I think the comfort of having a full and fulsome discussions in private with people in the caucus room really does put people at ease a lot more.
Right.
One of the things that I really enjoy as part of the process in mediation is allowing, especially in injury cases, the plaintiff to speak at the beginning, at the onset, and really have that opportunity to tell their story and see where they're at. And do you find that's really effective in letting the magic happen and having those discussions flow from there?
Yeah, I think that's probably the most important thing is, particularly if you get a plaintiff who takes the time to prepare something, like to actually sit down and sometimes it's excruciating for the lawyers because they've already been through an examination and read all the documents and they've heard all this stuff before. But as a mediator, I think it's really important to let them know that hearing their voice is really important and that they get a chance to speak and to actually I don't know if venting is the right way to describe it, but I think it's just being heard one more time in an environment where all the parties are together. The other thing I find is really, really helpful, because it's my practice to read every page of people, whatever people give me, is I think for both parties, but particularly for the plaintiff in an injury case, they take great comfort in the fact that I know everything about their case. So I will say, well, I read that doctor's note, or I saw that, your child was really ill around this time and it caused you problems or whatever. And I think they say, okay, well, yeah, this person has taken the time to get to know me and my case. And so there's a real personal aspect to that. And again, you're not going to get that out of a judge. The judge can't wade in like that. And I just say this to you, one of the reasons I never became a judge is because I'd rather be in the action, either in a courtroom or in mediation, rather than just having to sit there sort of sphinx-like and take notes and not jump into the fray. I don't think I was hardwired that way, but I do like the interaction and the communication that you get in a mediation.
Right. And I guess we've kind of jumped to a different section here, but I mean, speaking of, techniques and approaches to mediation, how do you, in addition to reviewing documents, how do you go about preparing for mediations?
Well, the first thing I'll do is I will read every page, but I'll try to do it well in advance of the mediation so that I can really ruminate about it. And I find that if I do that and I revisit it just before the mediation, I always make notes about where I think things should go, and I think try to predict where they probably will go, so that I can think about what I might say to people in various scenarios. But I think you guys are both very, very good counsel. And one of the things that I find interesting is that if you do personal injury work, for example, and you throw a set of facts at a personal injury lawyer, like the three of us, very often all of us think about it in our experience in terms of what the claim might be worth. We might be within dollars of each other and within dollars of what it ends up settling for. And I think people need to understand that assessing a damage case when someone's hurt is not a science. It's not a science. You just, you can't take an AI approach to it and just say, well, here's all the facts and I'm going to spit out this number. There's so many factors that come into it. And in the end, using all those factors and experience, you can come up with a really good idea of what a case is worth. And I, and those factors can include everything right down to, I don't think, you might say, I don't think this person is going to be a very good witness at a trial, or this person has said very inconsistent things to various doctors or caregivers, and they're going to have a problem at trial with this. All those things might diminish from a higher award or maybe lead to a lower award, but you got to take all those things in the mix. And so that's why I like to have a really close look at everything and then step back from it for a while. I think it's important just to have some time to think about it.
Yeah, and do you get an idea, again, coming back to that Lisa seminar materials we talked about, they sort of delineate two different types of approaches. There's more the interest-based approach where you're sort of getting more into the emotions and needs and interests of the parties versus evaluative mediation, where you are the expert, you're providing the advice. Do you get an idea beforehand of, what type of case it's going to be, or how do you go about determining what approach you might be using?
Well, I think frankly, the interest-based approaches really comes more to the fore in things that are supremely personal, like fighting about custody of your kids, or access to kids and all that sort of stuff. So I take a start at least on an evaluative process, and for people that might understand that, what that means is I'm there with some expertise to try to facilitate things. In terms of the cold black and white sort of facts and the law and the materials that before me, whereas the interest-based stuff does come to the fore when you realize, and usually it happens in caucuses, that someone will tell you, I have certain needs here that need to be met, or I have an Achilles heel in this case that you need to know about, and then that really changes things because it takes it to a more personal level. I had a mediation not that long ago with a fellow from Ethiopia, and I've actually spent a lot of time in Ethiopia, and so I started to talk to him in my broken Amharic, and it really changed the whole tone of things. I think there was a level of trust that was created, and a real sort of a more human level, so that takes you into more of the interest-based things, as opposed to, again, that's supposed to be almost more like an arbitrator, which really is not what you should be doing. Now, I will just say this, backing off of that from an interest or evaluative approach, there are some mediators who are can be battering rams, really, is the best way I can put it, and very forceful with people and arm twisting. And sometimes the lawyers want that type of a mediator that's not going to get into interest-based things and is going to try and force things through because maybe the client needs to have a dose of reality and someone being forceful with them. So it's a mix.
How do you handle that when you're in a difficult situation where the parties are unwilling to compromise, you're at a standstill? What do you do?
I put the fear of God in them. About what they're risking, and this is maybe a good time to talk about the risk. And one of the risks you have when you go to trial, and I tell people this, is you don't get to choose your judge. You get a judge that's chosen for you, and it might be a judge that has absolutely no idea about the area of the law and personal injury. The other day I mediated for a fellow who was struck by a car when he was on his bicycle. The question was, who was at fault? There was facts on both sides of whether it was a driver or the bike rider was being too aggressive. And one of the things I said to them is, what if you get a judge who can't stand the way people ride to work on their bikes in the morning? Or a dog case. I've had several dog bite cases and things like that. If you get a judge who is a dog lover, you're gonna might have a different result. And so I try to tell people, when you throw it into the hands of somebody else, yeah, you're resolute in your position, but almost anything can happen. And it's just like we talked about the other day. A good example is the Donald Trump um, civil trial that he just lost, or the criminal trial that he just lost on all 34 counts. One of the interesting things is people who were sitting in that courtroom for 6 weeks or whatever it was were saying, when they said, "What's going to happen here? What's the jury going to do?" They said, "I have absolutely no idea." It wouldn't have surprised them if he was acquitted or convicted. And that's what I try to tell people: is like, man, you do not want to put all your eggs in this basket, because you might be sorely upset when things go sideways for you in court.
Right. And that actually makes me think of something else. Have you gotten into situations before where you're dealing with, it's more so it seems like the lawyer is the one that is, comfortable pushing ahead, and they're sort of saying, no, we're going to go to trial and all this stuff. But you kind of get the sense that the litigant, it's first of all, not in their best interest, but also not something that they're wanting to do either, right? Like, does that add an extra level of difficulty for you?
Yeah, it does. Although it adds another interesting layer or texture to trying to assess what would happen, which is when you do have a lawyer, perhaps a very good lawyer, who is not scared to go to trial, and has maybe a experience, that can be used as a tactic by those kinds of lawyers to also put the fear of God on the other side. I'm I'm going to go, and I go all the time, and the usual blah 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 about pounding your chest and everything. But I often find that when lawyers do that, um, with respect to the plaintiff, very often you can tell that they don't necessarily want that. You can tell in their eyes that they're petrified of having to, most of them anyway. And also you see the clients who are going to pay for the trial on the defense side, um, just trying to get the steam out of people's engines to just let's try and get this done. Uh, it's just I'm sorry, as a guy who was trained exclusively to be a courtroom lawyer by very, very, very good people. I don't believe it's the way to go for people anymore. I think 30 years ago I wouldn't have said that, but now I'm a firm believer that it's just not the way to go.
Well, that actually has me now jumping to another area in terms of skills for lawyers in that they've had to develop in terms of mediation. So whether it's that seasoned trial lawyer or somebody newer, if you are going to be, representing yourself in a very confident light in the mediation or putting forward these big numbers and things like that, it's very important for them to communicate well with their client in order to temper their expectations. Is that right?
Oh, that's the most important thing, Kristen. Honestly, is that if you're gonna goose up your case, so that you not just your best foot forward, as I said, but sometimes way better than your best foot, you had better manage your client, and they had better know where the real goalposts are, and not the ones that are in the briefs. Because if they don't understand that, let's just give an example of someone's brief says the case is worth $1 million, and by 2 o'clock in the afternoon they're down at $400,000. There might be a client sitting there saying, I'm losing about $150,000 an hour here. Like, that's exactly going on here. So client management is extremely important from a plaintiff's point of view. And that's the other thing we'll say about a mediator's role, which is I think it's important and helpful for plaintiff's lawyers to have someone with experience, um, from coming to the client and saying, look, I'm telling you, this is what's going to happen with respect to this head of damages, or this is the problem you're going to have with liability on a slip and fall. Sometimes you have to say to people, um, you know, you slipped on a piece of ice on the sidewalk that was the size of Antarctica. A judge is going to say to you, you should have seen that. Maybe it was a hazard, but you're going to bear some responsibility. And I think the plaintiff's lawyers appreciate that help, that kind of help from a mediator saying, look, let's get more realistic about things here. So I think that's a really actually important role without telling people what to do. Um, um, and at the end of a mediation, very often plaintiffs will say to me, Allan, is this a good settlement? Uh, or what would you do here? Would you accept it? And then that's when I can go into a speech about why it is a good or isn't, or why they probably should take it. And I think that's a really important part of mediating.
It's an interesting process where it's the first time many of these people have had another individual comment on their case outside of their counsel. And part of that seems really navigating client expectations and seeing where you're at that day. Do you find that many litigants really appreciate, we spoke about some of the challenges with trial, but also how far out it's going to be, what that process involves? We spoke a little bit about predictability, but do you get the sense that people truly understand that, or is that a huge part of your role in communicating that fully?
I think and again, it doesn't go back to the full fear of God thing in terms of what they should be really worried about to go to trial. I think one of the other things that's really important I tell people is that with mediation, whatever is offered on various heads of damages or the bottom line number, that day there is absolute certainty of what you're going to get. And I think that's one of the most important things to tell people, and to say to them, look, here's one of the problems. You were badly injured in a car accident. You could walk out of the mediation room not settling, get into your car and get into another horrible car accident. And that's going to change the entire complexion of your first case, because all of a sudden you'll have two insurers pointing at each other about who's at fault. You might buy yourself another 4 or 5 years before you get to trial. Whereas if you can settle today, you have absolute certainty that whatever happens to you when you walk out of the door isn't going to matter to that number. And the other thing that I think that people don't realize is that in injury cases, if unfortunately, some people pass away in the process. When that happens, your damages go up in smoke, except for your out-of-pocket expenses or your hard damages. But all of your pain and suffering damages and other damages just go up in smoke. And I think that's a real eye opener for people when they hear that from me, which is, here's your chance. You're going to know exactly what you're getting in your pocket as of today. And that's the other thing that happens, and I should say a lot, is that when there's a long sort of a period at the end of a mediation where the plaintiff is making a decision, really good plaintiff's lawyers at that point walk them through exactly what they're going to get, exactly how much the fee for the lawyer is, how much is going to get into their pocket. And I think the last thing that people are always surprised at, I don't know why, but when you settle a personal injury damage claim, the money you get is tax free. It goes into your pocket tax free. And I think, for some people, for example, if they settle and they get $100,000, for some people that's the equivalent of 2 or 3 years of tax free income. And when you put it in that perspective, and then tell them what their risks are of going to a trial or like I say, getting into another accident or even dying, it's an eye opener, I think, for some plaintiffs.
We've kind of gotten into quite a bit about, without asking the direct question, the sort of the do's and don'ts for plaintiff counsel. I'm curious if you have any thoughts about, the do's and don'ts of mediation for defense counsel or defendants, insurance companies, things of that nature.
Well, let me start with the biggest don't. And the biggest don't is there's always an opening session. And as we've said earlier, it's very important for the plaintiff to feel like they're getting heard and to get some airtime. And to do it in front of me and the adjuster usually is coming from the insurance company who's probably never seen this person. And I think that's a do from everyone's point of view is letting the plaintiff have their time to talk. The don't is don't use the opening session to turn this into a punching bag and start telling the plaintiff all the things that are wrong with them and their case and their lawyer's position, because it's usually all in the brief. It doesn't do any good for people. The playbook is this: thank you for coming. We're here in good faith. We really are hopeful to resolve this today. We've read your material very often, and a lot of lawyers are very good at this. or adjusters will say, we're really sorry this happened to you in the first place. We really sincerely are sorry. We wish it never would have happened to you. And we're going to do our best to compensate you. And to say, it may sound like we're just talking about dollars and cents and it's impersonal, but it's not. We have to figure this out. But we're very mindful of what's happened to you. So those kinds of conciliatory um, and good communication, that you've listened to this person and that you're taking their claim seriously, and that um, that you're sorry that they have to go through this. I think it really helps. I just don't think. I think the biggest don't is don't use it as a chance. That opening as a chance to completely re-advocate your position, and particularly tell the plaintiff all the problems they have. Doesn't work very well.
So, key defense lawyers, interest-based, not evaluative.
Yeah, and that's a really good point, Kristen. That's a good way to illustrate the interest-based thing, which is forget about all the law, forget about the cold hard facts, forget about all the medical records and income tax returns and case law at that moment, and turn it into more of an interest-based overture to the other side, because I think then they'll understand that somebody who's actually does have their interests in mind. And so that's a really good example.
I imagine for you, you go into so many of these and have a lot of materials you have to review in advance. How can we help you in terms of brief writing and how we're presenting evidence so that you have a true understanding of either of our positions?
Well, I think the first thing I would say for people about briefs is if there's a point you want to make that is uncomfortable, you've got to gird up and make it. So if one of your big selling points to limit a claim is that the plaintiff is not a very credible or good witness or has credibility problems, you've got to say it. Say it in the brief, as hard as it is. After what I've just told you about how important it is to try to take a bit of an interest-based approach, but if you're going to take that kind of a position, say it. It's like judges say to me. About what if a judge makes a decision? If they don't think the plaintiff is credible, they need to say it in their judgment. They need to say it in their judgment because that's going to make a difference on what the appellate court might do and could do. And I would just say to people, if you have hard positions and you really think, I think this might break this negotiation down because we're being so stalwart about it, but I think you have to, because you can always, again, it's letting the other side know what might happen in a trial. And I think that's really important.
And now I'm going to kind of sidebar off here. So we've been talking a lot about the preparation and the facilitation. But we touched a little bit on arbitration earlier and trial and the unpredictability of these types of things. What about judicial dispute resolution? Like, leaving aside the fact that you can't get into JDRs right now if you wanted to. I personally think there's a lot of advantages to using mediation over JDR. Would you agree with that?
Yeah, I don't think JDRs work. I don't think it would be a really exceptional judge who was any good at this. And in fact, judges have talked about this. In their world, they leave their office in their robes. They take an elevator down to the back of the courtroom. The door opens. Everybody stands up. They're sitting 10 feet higher than the rest of the people. They're completely in control of their courtroom. And then they have to sit there and listen to evidence. I think it's very unnerving for judges to be in their street clothes. Sorry, I sound like one of those old wrestling shows. But for judges to come in their street clothes and walk into a room and sit across the table from people at the same level and look people in the eye, it's foreign to them. And so I don't think they're very good at it. Some of them are. I'm not gonna run down the judiciary and say there's people that don't have those skills, but that's not what they do all day. They don't try to facilitate things. They're there to make the hard decisions and to listen to the evidence. And so my experience with JDRs is that judges didn't like them. They were super impatient. And at some point, we'll talk about again, going back to the Gandalf magic of all this. It is actually amazing that sometimes it's on the 7th or 8th round of negotiation where everything comes together. And you got to hang in there. And I find that judges do not like to hang in there. Some of them are blunt and say, "I'm not going to be here all day. I'm just not going to sit here all day." So I don't, and they're not trained to be mediators, and so I don't think they're comfortable with it. And I stayed away from it. Now, again, getting back, someone may need to have a client who gets to sit in a room where the mediator is the Honorable Mr. or Miss Madam Justice so and so in the courthouse with all of the trappings of the courthouse, and so they know that it's a serious matter. But I just don't think it works most of the time.
Right, that just made me think of. Sorry, that made me think of something else with regards to, again, being in the mediation position, having more control over the process, control over who you're going to be using, and just making them feel a little bit more engaged. But yeah, I remember being in one mediation a JDR. I've had successful ones, and I don't mean to, sneeze at them, but I had a judge just come in and clearly she wanted to go to lunch or something. Because she really did not have any more time for kind of the back and forth and the positional stuff anymore. So
well, and then the thing too is that my favorite JDR story is a judge came in. She was famous for her unbelievably fantastic clothing that she would wear, very high-end clothing. And there was a whole bunch of us in the room, and she came in on the first case, and then she went off to set up the breakout rooms or something. And the plaintiff's lawyer turned to all of us defensively and said, "Well, I don't think this is going to be a very successful day for me." And we all said, "Why?" And he said, "I think her outfit is worth more than this claim." So it's a weird process to have a judge, like I say, not to be in that position of sort of. It's not. I'm not talking about power. I'm just talking about appearance. That they're in charge, and I think it's hard for people who spend their life being in charge to just back off on the process and facilitate rather than dictate.
Well, I almost wonder if it would have been beneficial when we were doing the JDRs if it was more of a voluntary, which judges want to do this, because we have some excellent retired justices and judges doing mediations now. And I do think there is some benefit to having that title going along when you have a difficult case and somebody needs to better understand things. I suppose if it was, maybe it's more likely for them to be voluntary when they're starting to get paid by the hour for it. But still, like you said, it's important for the people to want to do what they're doing and like what they're doing, which you clearly do.
Yeah, and what I like the most about mediating now is that I've had so much trial experience that I sometimes when I read things in briefs and both after I can sort of see what will happen at a trial in slow motion, and I can pass that along to people. And I started my career in my articling year with my principal. We ran 3 long trials in my articling year, and then the next year I was asked to junior on trial that took 2.5 years. So I spent 2.5 years of my first couple of years of working in a courtroom. So I think I can bring as a mediator that experience and sort of insight to people, and I do like that because I've been lucky to run a lot of trials, and I think I have a pretty good compass about what will happen if people go to court.
No, absolutely, and I mean, there's just this impression I think that litigants have, and even lawyers, where it is a retired justice. But I completely agree with you. People that have a lot of trial experience, they just have a better idea of the ebbs and flow of trials and how things can change and how things can go completely different than expected. And so I personally am perfectly happy to use non-judge mediators such as yourself. So not a slight at all.
Well, but the thing is that I think sometimes the advantage of having that experience like, for example, what I always tell people in mediations about their economic or financial losses or their losses of income or whatever is they may have all these explanations for everything, and I always just say to them, judges love tax returns. Judges adore tax. You can get up there and wave your arms all you want about how much you're going to make, who you're but the fact of the matter is judges love tax returns, and that's where they're going to start. And the second thing is that judges, if someone says they're really injured, but the evidence come out that they've golfed 50 times a year, they're going to lose an awful lot of air out of their case real quick.
Mm-hmm. Absolutely.
They paid for it after, Allan.
So I think we touched on some parts of why being part of that process might not be for everyone. But what sort of personality qualities do you think contribute to a successful mediator?
Well, I think the first thing is you have to have a certain kind of personality that allows you to connect with people. And I know lawyers who I hope are going to go into the mediation business because they are very personable. They put people at ease very easily. Maybe they just are the kind of person that you'd be okay going camping with. That you wouldn't mind it. But I think that that's the biggest skill is somehow connecting with people. Again, so I just say this to people who are really good, straight line thinking lawyers that are really good at going through the paper and focusing and stuff. You have to have. There's a real human element to mediation, which I think is really important. So I think, and I think, like I say, surprisingly, Kristen, but basically you said some of the judges who I never thought when they were retired would be good mediators actually turned out to be good mediators because they actually. I think now that they're done being a judge, they actually be involved being out with the rest of us common folk, right? They like the action of it, and so that's I think the biggest skill. Just having some people skills is really the most important thing.
Well, and I personally think the more mediators there are out there, maybe not for the business of individual mediators, not the better, but I think it's good to have some, not just variety for the litigants, some competition amongst the mediators to keep things, effective and mixing things up and experiencing things with different people, so that we don't get, what's the word? Just complacent and lazy.
Right. But there's other, you talk about styles of mediation. Some people really try immediately to get people out of that sort of conflict mode that they're in or adversarial mode. I think you can't do that too early in a mediation. I think it's nice to try because some people complain to me that certain mediators seem to just want everybody to hug it out, just to hug it out and get it done. And I think you got to let that adversarial side of the beast be there a bit because I think people also the lawyers want to advocate their position and they want to be heard too. Or an adjuster, for example, may have a very strong view of things. And so again, there's all sorts of different styles. But and maybe some people want a mediator that wants everyone to hug it out. I don't know.
Yeah, well, I know in my personal experience, there are certain clients we have that have an expectation of you not necessarily being more adversarial, but our job is to be an advocate and really just they want to hear and make sure that you clearly understood our case. They may not have read our whole brief or whatever, right? So that I think that plays into it a bit too.
Well, I think the thing that people lose sight of too, as well, is that not just the adversarial thing, but when we get back to interest-based mediation at its basis level, at a mediation for a personal injury case, the people do have both sides have interest. The plaintiff has interest to get out of the litigation and to get money in their pocket and to be fairly compensated. But on the other side, the insurance company really wants to close the file. I think almost everybody comes to the mediation from an insurance side or from a defense side, saying, I'm going to do my level best today to close this file and maybe to stop the bleeding on how many costs are being incurred, or because nothing good is going to happen in the next 2 years to this plaintiff. It's just going to get worse and worse, and I want to get this done. So that's the thing about looking at things about what people's interests are. I think when people come to a mediation, they're 99% of the time their interest is to get it done.
Well, that's why you got to schedule mediations for November and December, because then the insurance company really wants to close their file.
That's right.
Right. Year ends come up.
That's my piece of advice. Well, so we've actually gotten ourselves very close to the end of our time here. We haven't gotten into all the topics we might have wanted to, but you spent some time praising us, Allan, and I do want to say that you've been an excellent guest today. You're very insightful and very knowledgeable, and it's exactly the same when we have you on as a mediator. And I found you to be very good at finding a balance between the interests of the plaintiff and the interests of the defendant, and coming across as truly very impartial, and they're working for both sides. And can't say enough good things about how much I've enjoyed working with you.
Well, and both of you, and people need to know that both of you have used me as a mediator, and I think you're both excellent counsel. We get things done, and I appreciate. And this is the thing that people need to know about. One of the most important things that the lawyers can do for me is to tell me very early on where the landmines may be, or where their big problems may be, or maybe what I need to know about the other side that I don't know, but that you do. And both of you are superb at letting me know where the like I say, where I don't want to step in it with people, or I should know things. And I think that's an important part of a lawyer's job in mediation is again, let me know what the other person's interests may be too. So that's important.
Yeah, thank you, Allan. And I share Kristen's comments, and you're a very effective mediator, someone that we know that we can rely on. And I think you are fantastic at connecting with clients, and from our client perspective as well with the adjusters. So you are someone we certainly recommend, and I'm sure we'll continue to use you in the future and mediations going forward. But before we wrap up here, I just want to know if you have any thoughts about where do you think mediation is going to be in the future?
Okay, well, this is a good time for me to say that again. After all these years, I think our court system is quite severely broken right now, and I think that mediation is only going to get bigger and bigger and more common. I know that it's mandatory in Alberta now that you have to do some alternative dispute resolution, but I just think that, and I do think that they're trying to do it as well, which is they don't want us over at the courthouse if we don't have to be, and we're short of judges. It doesn't seem to be a priority for any government. I'm not going to pick on one or the other. They just don't seem to want to fill vacancies, and that leaves everything dragging and a lot of lead time before you can get a trial date. So I think the future of mediation is very bright, and in fact, I think we're going to get into a situation where some lawyers may go their entire career and never see a courtroom ever, and I don't know if that's a good or a bad thing. It's probably a good thing for clients, but I just think mediation is going to be the way of the future, and I think again. There's people. It's a personality-based thing, not just a skill set of. It's more of a personality thing, and I think it's good. We talked about it in Praveen and Kristen today. There's not one size fits all. There are different kinds of mediators. Sometimes you want an arm twister. Sometimes you want a hugger out. It depends on the case, and that's another skill that lawyers have to figure out: is who's the best mediator for this, and that's something that's important to give your client advice on.
Well, I guess that is all the time that we have for today. Another huge thank you to you, Allan, for joining us and sharing your expertise and your insight and your stories. yeah, and thank you to our listeners for tuning in. We will see you next time.
Yeah, and I'm sorry I didn't get a chance to cook anything for you, but we'll do that on another podcast. How's that?
That's
Absolutely.
No, that's a promise. Okay.
And in Italy, we'll have to go to Italy.
Yeah. Well, we won't get into whether next time there should be wine or not, but we'll talk about that.
Perfect. Can't wait.
Okay, guys, thank you very much. I really appreciate it. I really enjoyed this. It was great to do this with you. Thank you.
Awesome. Thank you.
You've been tuning into the Lawyer Up with HMC podcast with your host, Kristen Hagg. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.